friends, welcome to iExamB's Law Channel Legal Week. We started 300 most important law questions series and this is part 4 of that series. In this video, we will be discussing questions from Law of Contract, from Indian Contract Act and Specific Relief Act. This is the timetable that we are following for this 300 law question series. In the part 4, today we are going to talk about Law of Contracts. In part 5 on 21st of October, we will be discussing about Code of Civil Procedure. So come prepared, use this series as a medium of revision for your exam. Starting with the first question, as per the Indian Contract Act, what is the correct sequence of the following? Offer, promise, contract, agreement and acceptance. The correct answer here is A, E, B, D, C. First there is an offer, then there is acceptance to that offer. After acceptance, that converts into a promise. Then there is agreement and at the end there is a contract. This is given under section 2A, B, E and H of Contract Act, which define these terms. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. When the person to whom the proposal is made signifies his assent, the proposal is said to be accepted. When accepted, that becomes a promise. Every promise and every set of promises forming the consideration for each other is an agreement. Agreement enforceable by law is contract. Moving to question 2. A consent given under a contract shall be considered to be valid one if there is. The correct answer is free consent. This is given under section number 13, which defines consent. Two or more persons are said to consent when they agree upon the same thing in the same sense, and section 14 defines free consent. Consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. Consent is said to be caused when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation or mistake. Consent should be free consent. Moving to question 3. The law of contract is not related to which of the following maxims? The correct answer is E. Actus non facit reum, nisi mensit rea. We will see the meaning of each of these maxims and how they are related to Contract Act. First of all, actus non facit reum, nisi mensit rea. This means an act does not make one guilty unless there is a criminal intent. So both mens rea and actus rea should be present for an offence in order to establish guilt. This mostly comes in the criminal law and is not present under Indian Contract Act. Second is quid pro quo. That means something for something. Generally, quid pro quo means that there is consideration in return for something or something is being given in exchange for something. Thus, it signifies consideration which form the part of contract and passes from one party to another and thereby making the agreement valid and binding. It forms an essential part of valid contract. Next maxim is consensus ad idem, meeting of the minds or mutual agreement. This is mostly used in contract law and means that there is agreement between the parties to the contract or mutual agreement between all the parties to a contract. Next maxim is essentium mentium. It means meeting of the minds or mutual consent which is either expressed or implied by both parties to a contract. It is synonymous with the legal term consensus ad idem and is most commonly used in contract law. Mutual consent is one of the essential elements in order to constitute a contract as per section 10 of the Indian Contract Act. Next maxim is ex nihilo pacto, action non auditur. A contract without consideration is considered void and thus no right of action arises from a contract entered into without consideration. So consideration is a must. It is one of the essential elements for formation of a contract. Moving to question 4, which of the undermentioned contracts cannot be specifically enforced as per Specific Relief Act? The correct answer is all of the above. They cannot be specifically enforced. This is given under section number 14, which talks about contracts not specifically enforceable. Question number 5. As per the definition of contingent contract under the Indian Contract Act, which of the following is an example of contingent contract? The correct answer here is B. Priya enters into a contract with Payal to pay rupees 10,000 if the books are delivered to her on Monday. This is given under section number 31. If two or more parties enter into a contract to do or not to do something, If an event which is collateral to the contract does or does not happen, then it is called a contingent contract. So as per this definition and the above example, B is the correct answer, in which their delivery of books by Monday is collateral to the contract and not a part of the consideration. Hence, this is a contingent contract. Moving to question 6, which is that element which makes all contract an agreement but all agreements not a contract? The correct answer here is enforceability. All agreements enforceable by law are contract. Section 2H of the Contract Act defines contract. It is an agreement enforceable by law. Thus, enforceability means when promises are held valid in the court of law and the parties to the contract can be held liable to complete their promises, then the contract is said to be enforceable by law. When offer is made and it is accepted, it forms a promise. That promise or set of promises forms an agreement. This agreement or accepted promise plus enforceability will form a contract. Moving to question 7. The communication of a revocation is complete as against the person who makes it. The correct answer is when it is put into the course of transmission to the person to whom it is made so as to be out of the power of the person who makes it. So communication of revocation is complete when it is put into the course of transmission and is out of the power of the person making the revocation. This is given under section number 4 of the Indian Contract Act. So suppose here A wants to revoke an acceptance and he writes a letter to B and says that I want to revoke my acceptance. The communication of revocation is complete against A when this letter is posted, when it is out of the power of A and has been transmitted to B, and it will be completed against B when this letter reaches B, when it comes to his knowledge. Moving to question 8. Agreements, the meaning of which is not certain or capable of being made certain, are void. The uncertain agreements are always void. This is given under section number 29. Agreements, the meaning of which is not certain or not capable of being made certain, are void. Moving to question 9. Is there any time limit with respect to filing of suit for recovering the possession thereof if any person is dispossessed without his consent of immovable property otherwise than in due course of law? The correct answer here is 6 months. Suit cannot be filed after the expiry of 6 months from the date of dispossession. This is given under section number 6, and this question has been asked multiple times in IBPS SO and SEBI legal exam. Suit by person dispossessed of immovable property. No suit under this section shall be brought after the expiry of 6 months from the date of dispossession or against the government. Moving to question 10. Quantum merit means. The correct answer is both A and B. Quantum merit means as much as is earned based on the quasi-contract. It involves cases where a person gets benefit while the other party gets nothing. In easy terms, quantum merit means the amount one deserves. That means what one has earned. And this means payment in proportion to the amount of work that is done by that particular person. Normally, one cannot claim performance from another unless one has performed his obligation in full. However, in some cases, anyone who has performed some work under a contract can claim remuneration for the work which he already has done. That will come under the aspect of quantum merit. Moving to question 11. When two or more persons make a joint promise, the promissory may, in the absence of express agreement to the contrary, compel one or more of such joint promises to perform the whole of promise. This is given under section number 43 of the Contract Act. Question number 12. Express offer means. Correct answer is an offer made by words spoken or written. This is given under section number 9. Promises express or implied. In so far as the proposal or acceptance of any promise is made in words, the promise is said to be express. And in so far as the proposal or acceptance is made otherwise than in words, the promise is said to be implied. Question number 13. When does a contract become void which are contingent on the happening of specified event within fixed time? The correct answer is either B or C. Either if before the time fixed such event becomes impossible, or if at the expiration of the time fixed such event has not happened. This is given under section number 35 when contracts become void which are contingent on happening of a specified event within fixed time. For example, A promises to pay B a sum of money if a certain ship returns within 1 year. The contract may be enforced if the ship returns within the year and becomes void if the ship is burned within the year. Moving to question 14, consensus ad idem means. We have discussed this maxim in one of the previous questions as well. Consensus ad idem means all of the above, mutual agreement, meeting of the minds to agree upon the same thing in the same sense. Section 13 talks about consent and this maxim is related to section number 13. Moving to question 15. A person who finds goods belonging to another and takes them into his custody is subject to. The correct answer is same responsibility as a bailee. This is given under section number 71, responsibility of finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as the bailee. Question number 16. The consideration or object of an agreement is lawful unless. Correct answer is either of the above. Unless the court regards it as immoral or opposed to public policy, unless it is of such a nature that if permitted it would defeat the provisions of any law, unless it is fraudulent or involves or implies injury to the person or property of another. This is given under section number 23, when consideration and objects are lawful and what not. Moving to question number 17. Amit agrees to supply milk daily to Kailash, while Kailash agrees to pay the price of milk every month. Both of these are dash reciprocal promises. The correct answer is mutual and independent. Both of them are mutual and independent reciprocal promises. This is a type of reciprocal promise where each party to the contract has to perform their promises irrespective of whether the other party has performed his part or not. Hence, they are mutual and independent. Question number 18. Section 56 of the Indian Contract Act is based on which legal maxim? The correct answer is les non cogit ad impossibilia. This legal maxim, les non cogit ad impossibilia, means law will not compel a man to do what he cannot possibly perform. This section deals with those cases where the performance of the contract has been frustrated and the performance of it has become impossible to perform due to any unavoidable reason or condition. Moving to question number 19. A contract between the parties creates, the correct answer is rights in personam. Contract between the parties gives the person right against one person or party to the contract and generally corresponds with the duty imposed on said person or party. Contract Act grants right in personam to the parties of a contract and therefore parties to a contract have the contractual rights only against each other, just in personam and not rights in rem. Moving to question 20, last question of this video. A contract is not dash merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. The correct answer is voidable. This is given under section number 22. Contract caused by mistake of one party as to matter of fact will not make it voidable. So this is all in today's video. In the next video, we will be talking about the important questions from Code of Civil Procedure. And then on 28th of October, you will have one video on IRDA and PFRDA questions from these two apps, which are important for PFRDA legal exam. Stay tuned to LegalBee YouTube channel. This is your one-stop solution for all legal exams. We at iExamBee aim to unfold your potential and help you prepare for the exams 50% faster. If you have any queries, you can write them down in the comment below. You can also call us on this number mentioned on the screen. Thank you.